to me.
I'm sorry about that. I pressed the wrong button. Technology glitch. But luckily we're back in. There you go. So, right. So, as I said before, what this question is unpacking is whether or not there's been enough done to sever the joint tenancy by Mrs. Everidge. What was people's outcome on that? Do you think she's done enough in this situation?
No, I don't believe she did.
So what do other people agree with that? She hasn't done enough?
I think she did do enough, at least to sever it via equity.
Can you walk me through that, Sarah?
So basically, because it wasn't registered, I wouldn't really feel comfortable saying that it was severed at law. But she went through all the other necessary steps to sever it via equity in the transfer and arrangements, and then arranged it for a solicitor to have to do the final step, the registration. In which case, the final step was something that she couldn't do. So she had done all that she could do to sever the interest. In which case, it should have been enough to sever it from tenants in tenancying, joint tenancy.
And would you say, and in that situation, your argument is that it would satisfy the requirements of Section 200?
I would say so, yes.
Yep. So, what are other thoughts? Nicholas is saying no. Sarah is saying yes. Anyone else on board for yes? Do a straw poll, maybe?
I think Sarah's answer was a yes and no, and mine was a no based on the law. But if you're looking at the equity, then I'd have to agree with what Sarah said. Equitable, she's done everything she can.
Right. So we need to differentiate between whether or not the joint tenancy has been severed at law as opposed to in equity, and she may not have satisfied the requirements of common law, but it would appear that she's done, I think she's done sufficient as far as equity is concerned to recognise the severance. And if you go to Section 200, just have a quick look at that. We've done that before, but we'll go back to that. So again, this is just reinforcing really the judgment of Mason et al. In Corrin and Patton in terms of what's required. And it just talks about, that the assignor has done everything to be done by the assignor that is necessary in order to transfer the property to the assignee, even though anything remains to be done in order to transfer to the assignee complete and perfect title of the property, and provided that anything so remaining to be done is such as may afterwards be done. So basically the point is that the transferor or the donor has done everything that they're able to do. It may not have been all that is needed to be done, but they've done all that they can do in the situation. And I think if you have a look at the facts here, you'd probably say that Mrs. Everidge has done that. I'll just stop screen sharing that section. Now, the next aspect is, one thing I tossed up with a couple of groups is that this idea of the severance of the joint tenancy, the scenario here is that, it's basically still paper-based situation. What you need to think about and be mindful of is how this now works. Just if you're not, someone got background noise there, can you just mute your mic, please? Thank you. Just need to think about how does this work in an electronic situation, okay? Both in terms of where the documents are electronic, but also where you've got a full electronic conveyance. So if you've got a full electronic conveyance, as we know from first assignment, that's not mandated in Queensland yet, But if it is, and it's an option, it can be done as a full electronic conveyance if the parties agree. We don't have this idea of what was, what did Mrs. Everidge do with the certificate of title? Because she won't actually hold the certificate of the title. It doesn't actually issue as a matter of course from the Land Titles Office, okay? So it's not about the possession of documents and were you sufficiently careful with the documents and yes or no. It's about putting that thinking of what needs to have been done, or that everything that could have been done has been done within the power of the person in terms of the process. But it's not about focusing on documents and who had documents and who didn't have documents. So it's requiring us to reorient our thinking. Okay, so that's just a point I wanted to bring out. And again, as we move through the remaining topics in the unit, this is something we need to be thinking of as it arises. Okay, how will this work in the electronic environment, which is the way things are increasingly the case today? So we move on from there to the matters that were then attended to by Mr. Everidge in terms of the farm and the improvements that he undertook. But also there had been a contribution by Mrs. Everidge to farm activities. I mean, he didn't recognise those. It's a bit sort of bit backward looking in the sense of how we should and how we would view things today. But her contribution was, she did important business type work, accounting type work, which is very important, obviously, to the business of the farm. So what dimension of the puzzle does that toss up?
The size of her share, basically.
The size of the share, yeah. And specifically? Contributions, yes, very good. And the contributions fall into two categories. What are these?
Is it like essential?
Can't hear you, Tasman, sorry.
Is that like essential and non-essential?
Well, yes. I mean, issues around improvements to the property, and was this what was the nature of the improvements? Was that a shared understanding of that those improvements would take place? If they were improvements to the land and they enhanced the value of the land, then you would say that whilst a co-ownership subsists, co-owners are entitled to the benefits of those improvements, but they are also bear the burden of any costs associated with those improvements according to their share of ownership. Okay, and if it's a joint tenancy, then that's a shared thing. But if it's different, it's a tenancy in common, then it's according to their shares of ownership. And then if there's any expenses that have been identified, so is there any, like there's the improvements, of course. What about has there been any income coming in?
I'd be asking where the money came from for the supposed $100,000 he spent in the gardens and the $100,000 on fences.
Yeah. He funded that from his gambling habits.
Well,
right. Okay.
So
that's money then. Here's
the issue about what was the source of funds that were used for these improvements, and based on the facts, it would seem to be the case that all of them have been used for those improvements. But there's also facts there that says that there wasn't. Like says, Mrs. Everidge did not agree that spending the money on the gardens was a worthwhile project because they only added minimal capital value to the property. So where there's a disagreement, how does that impact upon the rights between the co-owners. This is another factor to be considered. And you've got this case law on this dimension of co-ownership, right? So you're looking at the rights of enjoyment between the co-owners. So in your casebook, for example, starting on page 606, okay? And what was, I mean, and have we got a situation here where the co-owners, I mean, at the time when this issue was arising, what's happened to one of the co-owners?
Well, she's passed away.
Right. So who's going to be taking action to enforce these rights?
Well, she transferred her interests into a trust and put her, was it her eldest son?
Yeah.
Yeah, her eldest son.
Not the son, not the son.
It'll be the executor of the will.
Brother.
So
The brother Joe. Yeah, brother Joe. That's
yes,
right.
the brother is the executor of her will. Okay. So the executor, of course, I don't know. Have you studied succession law or not? Yes. Yes. No.
No, I haven't as yet.
Okay.
Next term, I think.
So, you know, under the law of succession, the executor holds the legal interest in the property, in the estate of the deceased person for the purpose of dealing with the property in the interest of beneficiaries. Okay. Now, if we had concluded that the joint tenancy had not been severed, does the property devolve under her will?
No, if it's not severed, then it doesn't go under the will because of survivorship.
That's quite right. So the principle of survivorship, which is a fundamental feature of joint tenancy, means that property of a joint tenant doesn't form part of the person's estate when they die, but it devolves to the remaining joint tenant by right of survivorship, the jus as crescendi. But if we've concluded that the joint tenancy has been effectively severed, whether at law or in equity, right, and according to legislative requirement, then the share will then fall to the estate of the deceased person, and the legal interest in that property will then be with the executor or executrix, if it's a female, for the purpose of administering the estate to ultimately be dispersed to beneficiaries named by the testamentary instrument. And so with that, we get to that point, it's actually the executor of Mrs. Everidge's estate that is going to raise this issue about extent to which entitlements with regard to getting value from the improvements, the enhanced value of the property, extent to which the estate needs to contribute to any expenditures with regard to the property as a co-owner, right? Because now we've got a severed joint tenancy, so we've got shares of ownership. And then that's how that gets addressed. And there's case law, as I said, with regard to that, in terms of how you determine the nature of those entitlements and whether we're talking about monies that are being expended or monies coming into the property and so on, okay? And then you need to work out how the entitlements are divided between in this case, the estate of Mrs. Everidge on the one hand and Mr. Everidge on the other. Now, clearly, Mr. Everidge is not a very happy customer in terms of what's transpired, but the scenario reinforces this idea that a joint tenant can actually do this. It can actually do things to sever the joint tenancy. That may not be something that the other joint tenant is happy with, but it is possible. And it can be effective depending on how it's done and if it's been done successfully. Right? The other thing to just remember in tackling questions like this, as I mentioned a bit earlier, in Queensland, we've got the legislative provisions, and as a couple of groups indicated, we've got provisions from the Land Title Act, because all private freehold in Queensland is Torrens title. So we've got the LTA to consider, Section 59 in that regard, and we've also got Section 200 of the PLA, as I've already mentioned, with regard to the implications and requirements to have an effective severance in equity. Right, so let's turn back to problem 10.
Michael, we just backtracking a little bit, we also had a look at, touched on the fact that the marriage had broken down and they'd separated. Therefore, could there be a severance there?
Just before of the breakdown of the marriage, do you mean?
Well, the fact that she'd left the property, there was a breakdown of the marriage, and then she'd commenced the action to separate. Was there sort of, I guess, looking at the severance by agreement aspect?
Yeah, so that's another dimension, and the issue there is there's also implications of whether you've got a severance, and there can be implications there, for example, of the Family Law Act, if there's been an affected separation of marriage, and another way that can be done is by agreement. So yes, that's another dimension to be considered in terms of trying to resolve whether or not there's been an effective severance. And that's an aspect, yeah, it's quite right, an aspect within the scenario as well. That's actually a dimension that comes up in problem 10 as well. So, I mean, we're just on time, so we might just have a look at that, because that is another aspect of, as I said, in this problem 10, which is 6-5 in your Q&A book, which is on page 112 to 113. Now, this is a question that's, again, it's raising this whole point about severance of a joint tenancy not in an entirely dissimilar way to the way problem 11 has. And I've chosen this because it is also, it's contextualised within Queensland, which I think is obviously useful for us. And the question it has a couple of other dimensions to it, and it tosses up this idea that Michael's identified of, well, what are the implications of the family law provisions, or Family Law Act provisions, in a situation like this, where there's been a breakdown of relationship. That's one aspect. But there's another aspect within this scenario which is interesting, and that is what happens where you've got a situation, and we talk about this in a properly law sense, maybe a little bit too glibly, but what can arise in a relationship situation is that there can be violence, and the violence can get to such an extent where actually one of the joint tenants, one of the persons in this relationship, ends up dying through violent acts. So what we have to then ask is, well, what is the implications of that in terms of property that's held in that's co-owned and in a joint tenancy situation? So does anyone want to just proffer some ideas about that?
Yeah, I remember reading this. Sorry, can you hear me, Michael?
Yeah, Tasman, yeah, please.
Yep. I was a bit confused about it because basically it said that, so if Molly is actually guilty of Fred's death, then his share of the property goes in trust, but she doesn't benefit from it. Is that right? Or did I read that wrong?
No, you read that right. So if she's found guilty of homicide, so murder, the property will go upon a trust. But before that, it doesn't, like the act of homicide or murder doesn't dissolve the joint tenancy, but there's something else that then occurs, and this trust is recognised. What sort of a trust is recognised? Is it
A
A
constructive trust?
constructive trust.
constructive trust? That's right. And what's the rhyme and reason behind that?
So that the guilty party doesn't benefit from their actions.
Yes. And so again, what we have is, you see that the law is, on the one hand, it's saying, look, far as property law is concerned, we have a situation of joint tenancy, and the fact of there having been the commission of a serious crime in the nature of a homicide doesn't actually change that. So the result of that is that the surviving joint tenant, by the right of survivorship, takes the whole interest. But the law will not countenance a situation where someone that is committed a serious crime will benefit from that crime. And so equity intervenes to recognise in that situation a constructive trust where the surviving joint tenant, the murderer, holds the share of the deceased joint tenant on trust for the beneficiaries of that deceased joint tenant. So the law is basically working out an accommodation here, okay? But there's an interesting footnote to that I'll just bring to your attention. Where is it?
While you're doing that, Michael, that would also apply to manslaughter, it would appear from the readings.
Well, this is the point that, who is that, Michael? No.
Yep.
Yeah.
Just looking at the answer at bottom of page 117, it talks about unlawfully killing.
Yeah. That's there was a point there that I just wanted to. Where is it? Yeah, so at the bottom of 117, this is in the Q&A book, in the bottom of 117 and over onto 118, where the situation is less than an intentional homicide, there can be discretion in the court in terms of how the situation is best dealt with. Now, there's a reference there to New South Wales legislation. I don't think we've got equivalent legislation in Queensland. Not sure, but I'm not sure. I don't think we have. But there is that discretion where the consequence is not the most severe type of crime in this situation. You can see what, the law again, what's trying to do is, again, trying to work out some accommodation here. Clearly, we can't allow individuals that have committed serious crimes that have led to the death of their co-owner to benefit from that. So that some change and some intervention has been effected to prevent that from occurring. But if, for example, the co-owner has died as a consequence of an accidental act, should that be treated in the same way as a person that's found guilty of murder? You can understand that the law needs to have some flexibility here to say, well, no, they're different situations and the outcome should not be the same necessarily. Right? But it does raise, and the way it's discussed in your material doesn't actually, unfortunately, it's been what I want to say is it's been sanitised. It doesn't bring out what's actually happening. And what's actually happening is that we have significant issues in modern society around domestic violence. And domestic violence can go to such an extent where one of the parties in that domestic relationship can lose their life, can die, can be killed. And there have been instances of that in recent times. Terrible instances of that. We had one in New South Wales, I think it was about, might have been 12 months ago, where the father had returned to the dwelling and had murdered his partner and two of his children. I mean, horrendous, but it happens. These things occur, and the point is that the law has to have some response to this, so that on the one hand we have the established frameworks, but there needs to be a way of accommodating these extreme and exceptional situations. Okay, so that's just something to be mindful of, and in property law and land law, we're only one step removed from all of these other machinations of humanity. And all of that that's going on can then have an impact in terms of interest in property, because mostly people have interest in property. And then when things go wrong and things happen, we have to work out, well, what happens with those interests? Who has an entitlement to them? Have the nature of their acts and conduct affected those interests, even though they've dealt with them, even though they've made provision for them, and so on, even though the law might already make provision in the context of a joint tenancy through the right of survivorship, for example. So that's another dimension that one needs to always be mindful of in this area. And the other thing, and we saw this in the Term 1 course in Property Law Foundations, and we've seen it again a little bit tonight and from time to time, is that how other areas of the law can actually reach in and have an impact on the area of property law. So family law provisions, Family Law Act provisions can do that. In this case, we're seeing an example of how in the area of criminality, there can be intervention by either framework of law equity or indeed some legislation. And if you remember, if you cast your mind back to the Term 1 course, we saw instances there of this sort of rubbing between between property law and other areas of law. You might remember the case where the police came onto the property and sought to gain access, and then there were issues about whether that was right or not. There was another case where there was a trespasser on the land and the owner took action and basically shot the trespasser. And is that action reasonable in all the circumstances, and so on and so forth. So property law will rub up against these other areas of law, and sometimes one area of law has to give way to the other. but we also, in the end, we have to find a way of dealing with the interests that people have, in this case, in property, in land. And that has to be done in a way that's both reasonable, but also in a way that is according to a just outcome, all things considered.
Michael, I note in that on page 118 of the Q&A, it refers to the Forfeiture Act 1995, New South Wales.
Yeah.
I just dropped a PDF in there, which is a review on that particular act in regards to Queensland. And in Queensland, as at the time of the review, it didn't matter whether it was murder or manslaughter. That's it. Your rights were gone completely. That's currently under review, so it'll be interesting to see how that pans out.
Yeah, well, that's thanks for that, Nick. It's it's good to see that that's on foot in Queensland. It's also indicative that the situation is not uniform across the jurisdictions on matters of this nature. And then, of course, we can look at murder and manslaughter, and we can look at something less than that, right? So it's a question of looking at the totality of the situation. And yes, there will be different levers of the law that will be useful. But sometimes, of course, at the end of the day, the court just has to exercise its discretion to arrive at an outcome that is most just in all the circumstances. And one hopes that the law has and the court has that discretion to be able to do that, because that's what's right in all the circumstances.
Michael, as a property lawyer, a client comes to you and says that their father has just killed their mother. However, they're doing a deal with the prosecution to the effect that he'll be not guilty by way of insanity. What advice would you give then?
Nice little easy one to finish it. Look, that's very challenging. I mean, if a client comes to me and makes an admission of guilt, then that puts you in a rather difficult situation. If you're being asked to advise on their property rights, then you have to represent them in the best. And if you've taken them on board as a client, you have to represent them in the best way you can, and do the best you can in terms of their interests. But at the same time, you can't not acknowledge if the crime they're owning up to has actually been committed and that's proven, well, that you can't deny that, and you have an obligation not to deny that, and you need to point that out to your client. Now, if you're saying, Michael, that the client is also trying to plead insanity to get a better deal from the prosecution, that's just part of how you need to be responding to the situation that's been presented to you. But you still have to explain to your client, that what their obligations are here, and that their property rights may well be impacted by their actions.
I'd say their property rights would be impacted, because if they were clearly defined as insane, then everything that they owned would go into trust anyway, because they're not competent to manage it. So either way, they would lose out.
Mm. Those scenarios they're quite challenging for us as lawyers, you at the end of the day, you have an obligation to act in the best interests of your client, but you also have a higher obligation, and that is you have an obligation to the court. You cannot mislead the court, and you cannot not act in the interests of justice in bringing matters through the legal process in doing what you do in representing a particular client.
Unless we're talking about things like Timor-Leste, right?
Timor-Leste.
You don't know about the issue with the closed court under the Security Act, where Australia bugged East Timor.
I do.
Well, there was a full. There was a.
Yes, I do, Nicholas. But it depends on where you're positioning yourself. So, are you saying that you're a lawyer representing the government of Australia? Are you saying that you're a lawyer representing the government of Timor-Leste? Are you saying you're a lawyer representing one of the individuals that's been accused of activity that they shouldn't have done? See, again, as a lawyer, it really depends on where you're positioned in the scenario or in the process, and the challenge for a practicing lawyer is if a person or if an entity comes to you, or if you're in an organisation and you're acting for that organisation, then you have an obligation to act in their best interest. But at the same time, you cannot do things and conduct a matter in a way that is contrary to the interests of justice and that will mislead the court in terms of whatever that means in terms of the process you're involved in. And that's not always straightforward. And as depending on where you sit in the puzzle, you don't necessarily know all of the information, and if you're talking about that situation you've tossed up, Nicholas, you don't necessarily know everything that is known. If you're representing one of the parties, you don't necessarily have all the information that the Australian government has, or that the government in Timor-Leste has, for example. And this is part of the challenge. You can only do the best you can do in representing your client to the best of your capability, and that's what behoves all of us.
I just found it to be very interesting because it was on Late Line or something last night, and the barrister in question was given the okay by the federal government to talk to witness K, and now they're prosecuting the barrister for doing so, which is a rather interesting turn of events.
Well, one of the, when you move up into a geopolitical sphere, domestic legal rules and arrangements don't have the same operational effect. And lawyers need to understand that. So that most lawyers function within domestic, when I say domestic, I mean within territorial situations of how law functions. There are some lawyers that work at the international level and so on, that's right. But the great bulk of lawyers work within territorial limits, and they work on the basis of the law that governs within those limits. And there are certain things that are accepted and certain conventions and practices and whatever. As soon as you move up into the geopolitical sphere, all of that becomes a bit in play. And if you're in that situation, you've got to have an appreciation of that. But look, getting back to Michael's point, you can get complex situations that are presented to you. There's no doubt about that. And you have to do the best you can for your client, but you can't mislead your client, and you have to make them aware of the implications of what they're doing and the consequences in this situation that it has on interests that they have, including in relation to property and land. It can be challenging.
I guess that's why lawyers refer to barristers, right? for additional information.
Well, my own view about that is that solicitors often do that too often, because we are all legally educated and we all have the capability to make ethical and professional judgments and decisions. And solicitors don't need to have the reinforcement of a barrister who's an advocate to do that, right? But unfortunately, the way that the profession has devolved in many jurisdictions, even in those jurisdictions where there's fusion and in the sense that we've got you're admitted as a barrister and a solicitor, not just one or the other, because procedurally there's fusion, as we know, in all jurisdictions. You know, I think to some degree solicitors have tended to palm off that harder reality and decision making because they want to get on with the business of law and the transactions and dealing with clients. That's a balance to be struck as well. It's like all these other things. So, you know, obviously there's not a lot of money to be made in spending hours and hours and hours on one matter or on one client, because you're probably not charging the same rates that barristers charge, and that's a whole other debate about that. But
I guess that's why barristers specialise in Queensland, because there's no fusion. You can either go for one or the other. You can't be both in Queensland. That's the issue.
I know that, and it's the same in Victoria and in New South Wales. But we can have a whole other debate about that and about the role of advocates as opposed to solicitors and so on. But it is, at the end of the day, I think that, this is where I'll finish, right? At the end of the day, I think all of us as lawyers need to understand that we all carry the responsibility to be professional and to be ethical in dealing with our clients and in situations that present to us. And the other thing is that, you know, sorry, but this is going back to Michael's situation again, that he put to me. A client comes to you with a situation or with a question or with a problem. They often want to quarantine it and say, look, I'm only coming to you to give me the advice on this aspect because you're expert in this area or whatever. Right? You may well practice in that field. You may well have expertise in that field, but you're still a lawyer. And as a lawyer who's admitted to the Supreme Court of the jurisdiction, you have obligations generally, not just with respect to one compartment of the law. And so that's something that you can't forget or lose sight of as well. And as you go down the track, folks, and as you emerge from your law school days and you go out there into the big wide world as fully fledged lawyers, which I know all of you will, these are the challenges that lawyers face. It's part of our responsibility, it's part of our burden, but it's also part of what people look to us for. And we can't shy away from it. We just have to do the best we can and try and ensure as far as we can that in doing what we do and the advice that we give, it's also grounded appropriately in good ethical practice and also a good understanding of the array of responsibilities that we have. To our clients, yes, but also to other stakeholders in the bigger situation. All right, folks, we're just a little bit over time. We'll finish up there tonight. People have assignments, others have marking to do. So, and we might just finish up with, you can drop in, if you've got a takeaway point that you might have drop into the chat box from tonight's class, and then we'll wrap up proceedings. I'm going to next week offer a consultation segment following the class on the 30% assessment for any queries or questions that you may have. You will have seen I've already uploaded a recording on that, so hopefully that's useful for folks. Yeah. Good. Okay. We'll call it a night, people. And good luck with continuing on with your assessments, and I'll keep soldiering on with what I've got to do. And I'll have more information for you on that front next week. Hopefully, most of it resolved. Okay. So.
Good night, Michael.
See you then. Bye.